Hello, my name is Graham Ross. I'm a lawyer and a mediator. I specialise in resolving disputes between shareholders. You can find out all about me at boardroomresolve.com, but I'm not going to talk to you about that right now. I've got a very urgent matter to raise with you. If you are a sole director of a company and the company is run by what's called the model articles, they're the default articles that will apply when you form a company, whether you file, if you in fact don't file, bespoke tailored articles of association. And the problem is this, that because of a court case earlier this year, if you're interested, this isn't a law lecture, but that case is called Hashmi v. Lorimer Wing, and go and search it on the web and you can find out lots of websites, particularly lawyer websites, that explain what the case is about. But the impact is, and it's overturned the way we lawyers have thought about this for some time now, but the impact is that if you are a sole director and it's a model articles, no decision of the board of your company is now, or has been in the past, binding and effective in law. That could be the issue of dividends, filing of a claim or a defence, or what have you. Something has to be done now. Two things have to be done. You've got to solve the problem for the future, and you've got to solve the problem that all those decisions you've made in the past are no longer effective in law, and the problems that could arise as a result. As far as the current problem is concerned and going forward, well, you could appoint a second director or third, or however many directors you want. And of course, that then overcomes the problem of having a sole director. Now, the problem there, of course, is what happens in the future that the other director or directors leave and you are once again the sole director of your company. Are you going to remember that in that case you've got to either appoint somebody else straight away or change the articles? The simple answer, the more long-term answer, is of course to change the articles and make sure they now have provision for single directors to be effective in running the company. To do that, you need to pass a resolution with a 75% majority, a resolution of shareholders, that is, with a 75% majority. I presume if you're a sole director, it may be you hold all the shares there anyway, and therefore have yourself that majority. You have to file papers, and also, though, a very important thing is, what about all those decisions you made in the past? You're going to have to file a resolution and pass a resolution to validate all the decisions. Now that you have articles of association that in fact enable you to make effective decisions sole director, you then go and validate all those previous decisions. That's the information. Go ahead if you know what you're doing, or ask your accountant, or if you like, drop me a line and I can sort all this out for you very quickly. Okay, so that's Graham Ross, lawyer, mediator, specialising in shareholder disputes. There's that problem of the sole director. Go and sort it. Drop me a line if you need any sort of help. Happy to chat. Thank you.